think just to start, the shift away from the really traditional approach to employment, so the idea that you would graduate from college, walk into a job, work on a full-time basis until you turn 65 and retire with a lovely pension. I think the abandonment of that very traditional and pretty linear approach to employment it's not new. That's something that has been happening quite steadily for the last couple of decades, probably going back to the 1980s. And the increase in more atypical and non-standard and flexible working arrangements is something that the law has recognised and been trying to adapt to also to some extent for the last several years. So if you look back, we had the very first protections for zero-hour workers introduced back in 1997 as part of the Organisation of Working Time Act. Between 2001 and 2012, we introduced various different protections for atypical workers, so part-time employees, fixed-term employees, temporary agency workers, all of whom are becoming much more common, and all of whom the law recognised as being in need of some protections because of their non-standard status. In 2017, we introduced the Competition Amendment Act that allows certain categories of more vulnerable self-employed contractors to engage in collective bargaining for the first time without that breaching competition law. And even this year, in March of this year, we introduced the Employment Miscellaneous Provisions Act, which does a couple of different things, but at its heart was designed to provide additional protections for employees who engage in low-paid, flexible working arrangements. So I think it's safe to say the law gets that attitudes towards employment and towards the labour market and expectations are changing and has been trying to adapt to that. None of that is new. But what is new is the rate of change in the last 5 to 10 years even, and the rate at which businesses and workers alike are abandoning not just the traditional forms of employment, but even the more atypical forms of employment in favour of independent working models, freelance models, gig economy work. And part of that is because of technology and the ease at which businesses can connect with workers and find suitably qualified workers, and workers can find businesses who want to give them appropriate work, all at the click of a button, all using an app. You know, the lengthy recruitment searches are a thing of the past. So I think the ease at which those connections can take place has given rise to huge uptake in the number of businesses and workers engaging in this type of independent working for all of the reasons that Andrew's talked about. So from a business perspective, the ability to expand and grow and try new projects without the overheads of having employees. And from a worker perspective, the ability to work more flexibly, to have more autonomy. For certain workers, it's an opportunity just to supplement their existing income. And for certain workers, it's access to a labour market that they may not have otherwise had access to. Now, it's really hard to quantify the numbers of people engaging in the gig economy or in the freelance model because there's such confusion about what we mean when we talk about the gig economy, and Andrew's talked about that as well. But the one thing that all of the studies and all of the reports have shown is that the numbers of people engaging in some form of independent working are increasing year on year. So this is a billion-euro industry. We're talking about millions of workers worldwide, and it's clear that this is very much the direction that the labour market is going. So I think in that context, we have to ask ourselves, well, to what extent is the law keeping up with the new reality and these new ways of working? And that's just what I'm going to talk about very briefly this evening. Currently under Irish law, we just have two categories of worker status. You are either employed or you're a self-employed independent contractor, and we don't really have anything else in between. So unlike other jurisdictions, UK, for example, that have introduced a kind of a hybrid intermediate worker category, we haven't done that in Ireland, or either one or the other. And the difficulty for certain freelance workers, but particularly for certain gig workers, is that they often don't fall neatly into either of those two traditional definitions. So when we talk about an employee, and Andrew's touched on this a little bit, but an employee from an Irish perspective is someone who is engaged under a contract of service. So they agree to work for their employer. They generally work set hours that they're required to work for by their employer. They're given a fixed or a guaranteed rate of remuneration. They're subject to the supervision and control and direction of their employer, to the employer's policies and procedures and disciplinary processes. And in exchange for all of that subordination and the control that's exerted over them, they benefit from very significant protections under employment law. So, the right to a minimum wage, to paid time off, to protective leaves, to protection against dismissal. And, if the employer goes belly up, they're preferential creditors. And the employer owes additional obligations from a tax perspective. So the employer has to deduct tax at source. It has to pay employer PRSI. It's vicariously liable for the actions of its employees. So there's really significant implications to a finding of employment status. Contractors, on the other hand, are not employees, obviously, and they are essentially engaged under a contract for service as opposed to a contract of service. In other words, a contract to provide a particular service in exchange for a fee. And they have much more flexibility than traditional employees, so they're not subject to the same levels of control and supervision. They can decide who and when they work, and they can reject and accept offers of employment as they see fit. They can, manage their business to maximize profits, and, as Andrew said, they can be exposed to financial risk in a way that employees are often insulated from. And fundamentally, they fall outside of the scope of employment law. For certain gig workers, and Andrew's talked a lot about the highly skilled freelance model, so it is important to understand those distinctions, but there is a lot of negative media attention around the gig workers, so it's worth talking about. And for certain of those lower paid, lower skilled, blue collar gig workers, they often don't really neatly fall into either of those two definitions. So those type of workers are invariably engaged on the basis that they're independent contractors. That's how businesses operate. And it makes sense in that they are, essentially making themselves available on an ad hoc basis in exchange for a fee. They can accept or reject offers of work as they see fit. So much more flexibility than traditional employees. As against that, however, for certain gig workers, and again, not for all of them, for certain of those lower skilled, lower paid workers, although in theory, yes, they have much more flexibility than traditional employees, the reality can be quite different. And often there is a significant dependency on one or two organizations for the bulk of their income. And they can be subject to the rules of those organizations to make a living. And often those organizations will closely prescribe how and when and where they work. They'll set the rates that they can charge. There'll be no negotiation of terms. There's no equality of bargaining power. Yes, in theory, they can reject assignments, but there's often a fear that if they do that, they may be blacklisted. And certain organizations will require them to accept a very minimum number of assignments to stay on the books. So there's often a real dependency that doesn't quite align with our concept of someone being a person, an independent contractor engaged in business on their own account. There's a real dependency there. It's almost like a dependent contractor rather than an independent contractor. And that dependency exists without the benefit of the job security, of career opportunity, career progression opportunities, of the protection of employment law that applies to employees. And this is where a lot of the negative media attention is focused on, and rightly so to some extent. So how do we deal with this? Well, skipping through my slides, it's not easy. I mean, some jurisdictions have, as I said, introduced a hybrid status. So in the UK, for example, they have employees, workers, and independent contractors. And a worker is someone who's engaged to provide a service on a personal basis to someone who isn't a client or customer of the individual. And workers get certain minimum rights, so the right to minimum wage, the right to paid time off, but they don't benefit from the full protections of employment law. Now, Irish law hasn't evolved in that way. We haven't gone down that route as of yet. The way the Irish courts deal with it is they look at each case on a case-by-case basis and decide, well, on balance, is the relationship closer to an employment relationship, or is it closer to an independent contractor relationship? And often the line between those two concepts is very unclear. Now, the courts and the revenue commissioners have developed various different tests over the years to help them identify where an employment relationship exists. So, for example, in one of the leading decisions, Minister for Agriculture in Barry, the court endorsed the mutuality of obligation test, which is the idea that in order for an employment relationship to exist, there has to be at its core a minimum mutuality of obligation between the parties. In other words, a mutual obligation to provide work and to accept work where that's offered. Now, that particular test is pretty difficult for many of the gig workers to satisfy. Now, that's not the only test that applied. So in Roach and Kelly, the court endorsed the control test, which essentially looks at the degree to which the organisation controls how and when and where the services are carried out. And the greater extent of control exerted over the worker, the more that points away from an independent contractor and towards an employment relationship. The integration test is another test that's regularly used by the court and was endorsed in the decision of Ray Sunday Tribune. And that test looks at the extent to which the individual is integrated into the business. So do they wear the logos? Do they have the email account that all of the emails have, that all of the other employees have? Are they at the team meetings with all the other employees every day? Are they at the Christmas party? Does the business model fundamentally require them? Are they fully integrated into the business model in order for it to operate? And again, the greater the degree of integration, the more that points away from an independent contractor relationship. And then the last test I'll mention is just the entrepreneurial test, which kind of does what it says on the tin. So the courts look at the extent to which the person could be considered to be an entrepreneur. So do they have their own business? Can they negotiate the terms? Can they manage the services in a way to maximize profits? Are they exposed to financial risk? And the more entrepreneurial they are, the more that points away from an employment relationship. Now, fundamentally, none of these tests themselves are determinative, and the courts have emphasised time and time again, you have to look at the entire relationship as a whole, including all other relevant factors. So the contractual arrangements in place, the tax arrangements in place, the insurance arrangements in place, who provides the equipment, who provides the place of work. They're all relevant. And ultimately it'll come down to, the facts of a particular case. And that's difficult when it comes to certain gig workers because there isn't that clear distinction. And although we haven't had very many high profile classification cases in Ireland so far, the experience of other jurisdictions shows just how difficult and how grey this area is in the line between gig worker or independent contractor and employee. One of the leading decisions that many of you will probably be aware of from the news would be the Uber decision in the UK. So back in 2016, a number of Uber drivers brought a claim to the Employment Tribunal in the UK seeking worker status, and they had been classed as independent contractors by Uber, unsurprisingly. And they won their case, and they did so for a number of different reasons. So the tribunal looked at the contractual arrangements in place and acknowledged that Uber obviously structured the agreement with the drivers so that they would be independent contractors. But they said that didn't really reflect the reality of what was going on. And in reality, Uber exerted significant control over the drivers in terms of how, when and where they carried out the services. So, for example, all of the workflow came through the Uber app. Uber set the route the drivers had to follow. Uber set the fares they could charge. There was no negotiation there, no equality of bargaining power. Uber operated an online rating system, and if your rating fell below X number of stars, you could be cut off the platform. Uber drivers had to accept a minimum of 80% of the assignments they were offered when they were logged into the app. And fundamentally, the tribunal said the idea that Uber was just a platform connecting 30,000 independent businesses, because there were 30,000 drivers in London at the time, that was a nonsense, that was ridiculous. Clearly, the workers formed a fundamental part of the Uber business. And for all of those reasons, the tribunal said it wasn't appropriate to classify them as independent contractors. Now, unsurprisingly, Uber appealed the decision to the Employment Appeals Tribunal and to the Court of Appeal, both of which agreed with the original tribunal decision. They're now appealing to the Supreme Court, so it'll be interesting to see how that goes. But obviously, this has huge implications for Uber and its business operations in the UK. Now, you may look at that and think, okay, well, that's at least a pretty good steer as to how the courts will deal with these type of workers. But subsequent cases have shown just how difficult it is, and even similar cases have resulted in different outcomes. So in 2017, for example, Deliveroo riders brought a claim, and they were found, by contrast, not to be workers, but to be independent contractors. Now, their claim came before the Central Arbitration Committee in the UK, which is a body responsible for determining on trade union recognition. And as part of an application for trade union recognition, the CAC had to decide whether the Deliveroo riders were independent contractors or workers. And there was a lot of similarities to the Uber case that may have led you to believe, okay, similar to the Uber, they'll end up being workers too. So, for example, the Deliveroo riders got all their work through the Deliveroo app. They were subject to the policies and procedures of Deliveroo. Their bikes had to meet certain standards set by Deliveroo. Deliveroo recommended the route. Deliveroo told them how much they were going to charge, and there was no negotiation there. And fundamentally, the Deliveroo riders are clearly a key component to the Deliveroo business model. Can't operate without them. But differently to the Uber case, in the Deliveroo case, Deliveroo riders didn't have to perform the services personally. There was a right of substitution in the contracts that Deliveroo could point to and could show had been used by Deliveroo riders in operation, which allowed them to substitute someone else if they were unavailable. And the CAC said that in the absence of any personal service requirement, that was the death knell for any worker classification claim, because you had to have that degree of personal service to fall within the worker definition in the UK. Now, interestingly, in a Spanish decision brought against Deliveroo, similar circumstances, a similar model, the Spanish courts have found that Deliveroo riders are employees, not independent contractors. So it just goes to show how messy this area is, how much will come down to the very particular facts of the case, how the case is presented, the particular judge on the day, none of which is particularly satisfactory for businesses who engage significant numbers of gig workers or even freelance model workers generally, because of the implications of a finding of misclassification. If you find to have misclassified your employees, you're looking at liabilities from a tax perspective because you haven't properly deducted taxes, and there's not only just the back tax, but there's fines and penalties as well. And you're looking at potentially significant employment claims. And it's worth noting that most of the employment statutes in Ireland provide for up to 2 years remuneration in terms of compensation where breaches of employment law are found to have occurred. So really significant risks there. Certainly we have clients in Mason Hayes who will only engage contractors through a different company, whether it's a third-party company or a company owned by the contractor themselves, to try and put a certain distance between themselves to reduce those risks because it's so significant for their business. So how do we address this? How do we move forward, and where do we see this going? The answer is it's not clear, and the gig economy poses real difficulties from a legislative point of view for all the reasons that Andrew's talked about, because there are so many different types of gig worker, freelance worker, project worker, whatever you want to call them. There isn't going to be a neat one-size-fits-all approach, and it is really important that any approach we take does strike an appropriate balance between protecting the more vulnerable workers who only form one part of this new economy, and encouraging businesses and workers, and particularly the highly skilled workers who want to engage in this really valuable form of work. In terms of the options, one option would be to follow other jurisdictions like the UK, like Canada, and like Italy, who have introduced kind of a third category of worker. And it wouldn't be unusual for us to do or to look at what the UK has done and to steal the very best bits of their legislation and to copy it in Ireland. We do that pretty frequently. And the benefits of doing that would mean that, for those particularly vulnerable workers who maybe don't meet the high threshold of employee status, that they could still get certain core protections. And we could decide what those protections were. And from a business perspective, it means businesses who wanted to offer certain core protections could do that without having to offer the whole host of employment rights. So that is definitely an option. As against that, however, if you look at the experience of other jurisdictions that have that third party or third worker category, the practical experience is that businesses will inevitably engage people on the basis that they're independent contractors. They don't tend to use that third option. And they do that because they want maximum flexibility. And from a business perspective, if it's easier for workers or for people to bring misclassification claims because the standard is not reaching employee standard, you just have to get to worker standard. If they think that will increase the risk of misclassification claims, there is a real risk that could deter businesses from engaging gig workers. And that's not a good thing either, because if businesses don't feel comfortable using these types of workers, then if they want to expand or develop different projects, then that means engaging employees, which means additional overheads and potential costs if the expansion or if the project doesn't work out. And some companies may decide they don't want to take that risk, and that's not good from an economic perspective either. From a worker perspective, interestingly, a report by the CIPD, which is a professional body for HR professionals in the UK in March back in 2017, reported that 36% of gig workers were against increased regulation because there was a fear that might negatively impact their own personal tax status. So while regulation is absolutely an option, it's certainly not going to solve all the problems, and we'd have to be very careful about how we approach that issue. Now, there are other options. So, for example, you could look at putting in place some kind of statutory code of practice that, offers recommendations and encourages businesses to engage workers on fair and reasonable working terms. Deliveroo, in particular, have been advocating for some kind of statutory charter that would allow them to offer basic benefits to their workers, like insurance benefits, like sick pay cover in certain circumstances and training programs, and without that triggering any potential employee reclassification. So that's something we could look at as well. I think from a broader perspective, we need to be making sure that there are, governmental training programs and options for workers who are stuck in that lower paid, lower skilled section of the gig economy, so that they can get access to training and upskill and get into the higher paid, higher skilled sections of the economy, because they're not getting access to those training programs through the traditional employment relationship. And I think probably at a broader perspective, we also need to look at our social security system. So do we have a system that, provides access to basic welfare supports for people who move from job to job to job? And that's something we're starting to do. And it's recently been announced that self-employed contractors are going to get access to the dole for the first time from November, which is certainly a step in the right direction. but they don't have access to all basic welfare benefits. State illness benefit is one of the examples. So that's something that we certainly need to look at. So I think to come back to my original question, well, is the law keeping up with the new reality? Probably not. Is there a really easy answer to this? Unfortunately, I don't think so, but I think it's something that we have to look at, that we can't ignore because of how valuable this type of work is and how important it is to our economy. And also just trying to strike the balance between, availing of this beneficial type of work and also not abandoning those workers who are in the lower skilled, lower paid sections. Even if it's only a portion of the economy, they are, an important sector, and we can't abandon them either. So it's a difficult one, but it's something that we absolutely have to look at, given that this is clearly the direction we're going. And I think that is my 20 minutes up. So, questions?